So with our next session, we are going to zoom in on a key aspect of AI governance, which is the question of employment, bias, and equal opportunity. And let me invite on stage Commissioner Keith Sonderling, who leads the Equal Employment Opportunity Commission in the US, Mr. Avi Gesser, partner at the law firm Debevoise and Plimpton, and his colleague Anna Gressel, senior associate at Debevoise as well. Well, Avi, the floor is yours.
Sorry I couldn't be there in person. So with having Commissioner Sonderling is such a pleasure, I want to focus on AI and employment and how that is being regulated in the US and also in the EU. And so, I think we know that AI in hiring and promotion is become a sort of a widespread AI use case. Most large companies are using these tools to reach a larger candidate pool, which is laudable, and to consider a broader group of candidates that may be possible than if you were just to do this exercise manually. But there are concerns that exist over bias and transparency about how these tools are being trained and how they're being used. And as a result, there's just a lot of activity in the regulatory space for AI in hiring. And the New York City law that's coming into effect at the end of this month is one of many regulations that are either in draft or in final form that are going to take effect over the next couple of years. It's really going to make a difference, I think, in how these tools can be used. So with that, first question to you, Commissioner Sonderling, is how are companies using these tools, and what are the regulators really concerned about? And maybe give us a couple of examples of the misuses, sometimes inadvertent, but the misuses of these tools.
Yeah, well, thank you, Avi, for hosting this, and Anna for being a co-panelist. Also want to thank the Future Society for having me at the Athens Roundtable here in Brussels. It's been a great 2 days, and really great to meet so many people in person. So, when we're talking about artificial intelligence in the workplace, as you pointed out, Avi, there's a lot of use of it to help hire workers as well. But in addition to that, AI is being designed and sold to eliminate bias in the workforce. And how do you do that? By using computers and using algorithms and essentially taking out the H from the human resources, which is the human, which is the source of the bias. And obviously, bias in employment decision-making has been and still is a large problem. It's the reason my agency exists. It's the reason why we've collected almost $1 billion in damages from employers just in the last 2 years. But unlike other uses of AI, we're dealing with, a theme at this conference is using AI when it's coming to a fundamental civil right. And that fundamental civil right is to not only enter the workforce, but thrive in the workforce without any of that bias, without any of that discrimination. So whether you know it or not, AI is being used in all aspects of the employee life cycle. From the very decision to write a job description, it screens resumes, it chats with applicants, it conducts job interviews, it predicts if an employee will accept an offer and how much money they'll take for that offer. It tracks productivity, it assesses workers, and it's picking who's getting the valuable upskilling and reskilling opportunities, which is also a hot topic. There's even some AI software out there saying you're fired. So this isn't my forward-looking prediction for each of the components I just told you. There's software out there to sell. The HR tech market now has blown up. It's around $24 billion, and it's only going upwards. So it's really not a question, as you sort of alluded to, about companies, especially large companies, using AI in HR. It's which technology are you going to use, and how are you going to use it, and for what purpose, and how do you not violate anti-discrimination law? And and I will talk about some of the potential misuses, but I also do want to highlight that if it is carefully designed and properly used, it really does have the potential to advance diversity, inclusion, and accessibility in the workplace by mitigating the risk of unlawful decision making, because it can mask for typical areas of bias, such as race, gender, age, disability, a lot of the areas which are illegal to make employment decisions on, by using AI, can strip out any of those indicators or associational characteristics because of the training data it relies on. But when I talk about AI and the benefits, I also have to talk about that flipping what I just said. If it's poorly designed and carelessly implemented, it can then discriminate on a scale and magnitude far greater than any one person, right? So it can help HR by taking away some of these tasks and having it, instead of being manually reviewed by computers. But at the same time, if there's a discriminatory input or a discriminatory data set, it could really expand that discrimination. So there's either discriminatory uses by somebody actually going in an algorithm and filtering resumes or job candidates by protected characteristics, by their age, by their sex, by their national origin, which is unlawful, or discrimination that can occur, and I know this crowd knows it very well, by not having a complete data set. And if an algorithm relies on a data set that is not representative or representative only of the company's current workforce, what's this going to do? It's going to replicate the status quo, which then may continue discrimination when you're trying to use it for other purposes. So there's a lot to talk about. There's a lot of different technologies, but talking about it, AI in HR is a really good use case because it's happening right now as we speak.
And I think just first of all, it's all extremely helpful, and it was a fantastic sort of overview of the issue. But to just make it like really concrete, right? So we have a lot of clients who are using these tools who I think are in good faith trying to use them in the way that you're saying, which is let's try and reach a broader pool. Let's try and use them to get a diverse workforce and so forth. But you could inadvertently have the tools look at the wrong pattern, right? So they're great at pattern recognition, but they may look at the resumes of all your sort of successful executives and think, okay, well, what's really important is what college they went to, or what sport they played, based on the resumes. And so what's the EEOC looking at? What are you trying to make sure isn't happening with the use of these tools?
Well, just to take a step back for a minute for our international audience here, the EEOC is the federal agency in the United States responsible for enforcing and remedying discrimination in the workplace as well. So it applies to all work situations, including hiring, firing, promotions, training, wages, and benefits. Essentially everything I just told you employers are using decisions to make. So the problem with artificial intelligence is, or the problem that's perceived by employers out there who are lacking that guidance, who want more regulatory clarity. I've been trying to simplify this, and I've been talking as much as I can to make sure that employers understand that they're being sold these products by these vendors who are largely selling these products on something that corporations really want to do, like you said, Avi, in good faith, which is diversity, equity, and inclusion, and using these softwares to diversify their workforce, to find the best candidates for the best job without those historical biases that have prevented them from getting in the workplace or succeeding in the workplace, by being able to mask that or even broaden the data sets. But at the same time, there is a lack of clarity of how the laws apply to that. And what I've been trying to talk about and raise awareness of is that it does not matter in the United States who makes the employment decision. The employer is liable for it. So our laws are from the civil rights movement of the 1960s, and they're as applicable to employers who use AI to make employment decisions as they are to relying on humans, which employers have done since the beginning of time. And that is getting lost. And that's what I'm really trying to raise awareness of, is that the employer is liable for that decision. The software vendor is not, under the current state of laws, and I know we'll talk about the EU Act and how that's potentially going to change. But from an employer standpoint, what will the EEOC look at? What will class action lawyers look at? They're going to look at the results, and employer and see if there's discrimination. Now, if there's discrimination, how did we get there? Was it from a biased data set? Was it only using your current, example you gave, people from certain colleges, people from certain areas, and limiting the data pool of that? Or did you have an extremely diverse data set, but you had an algorithm that then limited it by having a bad actor in your company implement their bias and be able to scale that through AI, or was there something else? So AI actually can make this process more transparent of how we found discrimination, because what are we left with now? We're left with the human brain and an HR manager's brain. So for us at the EEOC to find bias, to find discriminatory intent, what do we have to do? We have to take depositions, we have to do interviews, we have to look at records. But with AI, it's at least more explainable and more transparent, where you could say, well, here's the data set that caused the problem, or here's the algorithm that caused the problem. And that is new, but the results are going to be the same. And we're always going to look at the results to see if discrimination occurred.
Yeah, that's really helpful and really well said. You know, and so it could be the data, it could be the algorithm, or it could be a rule, right? So someone could inadvertently put in a rule that says anybody who's got a gap of more than a year on their resume is going to get dinged, not realizing that that may have an impact, a disparate impact, an unfair impact on women who've taken time off to have kids or things like that. So Anna, turning to you, so you know, Commissioner Sonderling mentioned the civil rights laws. We're seeing a lot of regulation coming into effect, both in the U.S. and the EU. And you know, as you sort of look at the landscape, and I know you cover this very closely, I mean, what are some of the differences that you're seeing, both in terms of, you know, like the who's being regulated, the intentionality requirements, you know, sort of, is this entirely a bias issue, or there are also transparency issue? Just get a feel for like how are different regulations addressing this issue? And unfortunately, it sounds from discussions we've had, it's not quite harmonized.
Harmonized is far from the situation as we have it today. You know, just to, again, I think resituate for some of our international audience, some of the civil rights laws that Commissioner Sonderling and Avi were talking about are the our Title VII, which protects against discrimination based on protected characteristics, the Americans with Disabilities Act, which protects against discrimination based on disability, and we also have you know, laws that protect against age-related discrimination as well in hiring. And so, you know, when you look at those as compared to some of the newer laws that are coming out, what are the big differences we're looking at? I mean, as Avi mentioned, we're looking at who is being regulated. That's a really key issue that's coming to the fore. And why is it so important? I think Commissioner Sonderling hit this right on the head. The vendor marketplace for AI tools is really where a lot of this innovation is happening. It's not necessarily the case, it's actually rarely the case, I think, that employers are creating their own AI tools. Rather, they're usually using tools that are being procured, kind of available on the open market. Some of them are SaaS models. Some of them are vendor deployed models. And so you have this essentially, you know, what we might call the AI supply chain or value chain. I know that's terminology that's been used a lot over the course of the conference. And different regulations are situating themselves differently with respect to who is responsible for different regulatory obligations. So just to take a few examples, New York City now has an AI, an automated decision tool law that applies to any tools that replace or substantially assist decision-making with respect to hiring and promotions. That's very, very broad. We're waiting for kind of regulations to come out to provide some additional context on that. But what is that going to require? It's going to require a bias audit and substantial disclosures about how those tools are being used. And one of the big questions with respect to the New York law is who can conduct the bias audit? Is it really the responsibility of the employer, which is actually the entity regulated under the New York law? But how does the employer do this if they don't have the data? And should the vendor participate in some way if they're really the ones that have the models and the data about how that tool is being used, maybe with respect to one client in particular or across their client base? Meanwhile, you have the EUAI Act, which I know has been discussed in tremendous detail, which is different. It's really a life cycle approach that would expressly apply to both providers and users of AI tools. And hiring is considered a high-risk AI tool, which comes with obligations for providers of high-risk tools and users of high-risk tools. So what are some of those kinds of requirements for folks who aren't familiar, although I know many are? You know, some are pre-market certification and post-market monitoring requirements that apply to providers, as well as really a focus on enterprise risk management at the highest level. So making sure that senior leadership is in control of those tools. As to users, there are obligations that would require kind of record keeping and data assurance as to how the tools are using data and how they're operating in practice. And finally, I wanted to mention one California regulation that's really beginning to put the focus much more squarely in the US on vendors. And that's a key issue, is who is being regulated, that's coming up across jurisdictions.
And from our perspective, under the current law, the Title VII from the 1960s, we only have jurisdiction over the employer, the union, or the staffing agency, but just think the employer. So all these vendors out there can sell that these products are going to work. They could sell that these products were properly audited and they don't produce bias. But at the end of the day, if they do produce bias, our jurisdiction at the EEOC is only against that employer. And any statements that were made to the employer, any bias audits that were done for that employer in the aggregate don't matter. We only look at how it was used at that employer's exact location with that exact workforce. So that's something with the changing vendor liability that the EU Act is potentially going to do. We don't have that jurisdiction. Congress would have to amend Title VII to give us that jurisdiction. But it's just an interesting part about the limits of our current enforcement ability. But I know one last point. We talk a lot about enforcement, and especially because we're in the EU now, and who's going to enforce. Well, in the United States, you heard from an FTC commissioner. Now you're hearing from an EEOC commissioner. We can enforce. We're enforcing. We've had the ability to enforce for decades, and we can't wait for new laws or regulations or proposals. We have to do our jobs now because the software is being used as we speak, and we're doing that.
Nicholas, is this you telling us we're done?
Yes, I am sorry, but I can tell you've covered a lot of ground. So I want to thank you, Commissioner Sonderling, especially for making the trip to Brussels and engaging with the legislators and the regulators here. Thank you so much, Avi and Anna.